Hello, everyone. Today's Senate Majority Policy Committee workshop will focus on the prospects for a limited constitutional convention in Pennsylvania, as requested by our home senator, Senator Kristen Phillips-Hill, representing York County. To quote the 1776 document that started this grand experiment that we call America, we hold these truths to be self-evident that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. We've had a lot of discussion in the last 6 months with our governor about exactly what that last phrase means. Many who advocate for a limited constitutional convention in Pennsylvania argue that more needs to be done to place limits on the power of government to meet the Declaration's goal regarding the consent of the governed. This includes reforming the way that government operates, reforming the budget process, clarifying the checks and balances of our three separate but co-equal branches of government. I look forward to our upcoming discussion, hearing from our witnesses. With that, I turn the microphone over to Senator Phillips-Hill.
Thank you, Chairman Argall, and members of the Senate Majority Policy Committee, and my good friends and former colleagues in the House who've joined us today. I want to welcome everyone to Dallastown, and also to express gratitude to Mayor Myers, members of the Borough Council, and of course the Borough Manager, Connie Stokes, the woman who makes everything in Dallastown happen. So I'm honored to host this important discussion on a proposal that is relatively new to me, but not new to the General Assembly. And I also want to thank you, Dr. Joel Fishman, for your perspective and expertise as someone who is an expert on our state's Constitution. As the prime sponsor of Senate Bill 1035, alongside my good friend and former colleague in the House, Representative Frank Ryan, who is sponsoring House Bill 611, it is important to know why we are here and why this discussion matters today. For the last 6 months, each of our respective legislative offices have been inundated with questions from constituents seeking clarity and guidance during this unprecedented shutdown. The general feeling of the Pennsylvania taxpayer is frustration, anger, and disappointment. The state Supreme Court has emboldened the governor, and Pennsylvanians feel like they do not have a voice as unilateral decisions are handed down at late afternoon press conferences and through news releases. Senate Bill 1035 and House Bill 611 gives Pennsylvanians that much needed voice. And I'm very grateful for the opportunity to vet these pieces of legislation here today. Thank you, Chairman Argall.
Thank you, Senator. I want to remind all our panelists to keep microphones muted until it's your turn to speak to help us avoid background noises. Also keep in mind if there are any technical issues during this hearing, please contact our Executive Director, Josh Paul. Also ask everyone to strictly observe our time limits so that we have the opportunity for the discussion that takes place after the opening testimony. Joining us today, in addition to our host, Senator Kristen Phillips-Hill, Representative Frank Ryan from Lebanon County, and one of our home county representatives, Seth Grove. I understand that we'll also be joined by Representative Mike Jones. Representative Don Kiefer is joining us online, and also online the Vice Chairman of this committee, Senator Dave Arnold. Joining us from Western Pennsylvania, Senator Camera Bartolotta. From Northwestern Pennsylvania, Senator Michelle Brooks. From Lancaster, Senator Scott Martin. From nearby, Senator Doug Mastriano. And also up in the Poconos, Senator Mario Scavello. And also locally, Senator Mike Regan and Senator John DeSanto. So to all of us, whether you're here in person or through this miracle of technology that we continue to explore, thank you. Thank you for joining us for this important hearing. Let me turn now to Dr. Joel Fishman, the Associate Director for Lawyer Services Emeritus at Duquesne University School of Law, the Allegheny County Law Library, co-director, PennsylvaniaConstitution.org. Dr. Fishman, please begin.
Thank you. Good afternoon, senators and representatives. I wish to thank Chairman Argel and members of the State Senate Government Committee for giving me the opportunity to speak about the calling of a limited constitutional convention in Pennsylvania. My name is Joel Fishman. I have a master's degree and PhD degrees in English history from the University of Wisconsin-Madison and a master's of library science degree from Queens College, CUNY. I've been a law librarian for 47 years. I spent almost 40 years as the law librarian at the Allegheny County Law Library, and for the last 17, the assistant, then associate director for lawyer services at the Duquesne University Center for Legal Information. I've actually been retired for 4 years now. I'm a Pennsylvania legal historian and bibliographer with over 300 publications, including as one of the co-editors with Ken Gormley on the Pennsylvania Constitution, published in 2004. My most current research project is compiling an online biographical dictionary of the justices of the Supreme Court of Pennsylvania for the Supreme Court. For purposes of this meeting, I am the co-director of the Pennsylvania Constitution website at Duquesne University Law School since 2001, with the responsibility of adding historical information to the website, while the co-director, Professor Bruce Ledowitz, contributes current information. I've spoken before in 2007 to a similar Senate committee hosted by Senator Piccola on a proposed constitutional convention. My statement of that meeting is attached as Appendix A. Since then, I've also served as one of the 2 non-member commissioners in the Pennsylvania Bar Association Commission on Constitutional Reform from 2009 to 2012. My full resume is attached as Appendix B. As you all know, Pennsylvania has had 5 constitutions since 1776. The standard publication on the history of the Constitution is Rosalind Branning's Pennsylvania Constitutional Development, published in 1960, and her supplement as a research manual number 3 for the Pennsylvania Constitutional Convention of 1967. Professor John Geddes also has written an article on the Pennsylvania Constitutional Conventions, Discarding the Myths, found in the Pennsylvania Bar Association Quarterly. Another brief introduction more recently offered is by Professor Seth Kremer, Still Living After 50 Years, a census of judicial review under the Pennsylvania Constitution of 1968, published in volume 71 of the Rutgers Law Review in 2018. The initial Constitution, created during the first wave of the Constitution making following our independence from England, resulted in a constitutional convention meeting from June to September 1776. This convention, meeting separately from the General Assembly, drew up the most liberal of the initial state constitutions of the period. It created a one-house legislature and a Supreme Executive Council as the executive branch. This constitution, created under revolutionary times, differed from the succeeding creation based on the People's Sovereignty Clause of the 1776 Constitution, Chapter 1, Section 5. Those who opposed the liberal constitution, called the anti-constitutionalists, succeeded after the passage of the U.S. Constitution in 1787 to call for another constitutional convention. In 1789, the Pennsylvania Assembly placed an extra-legal call for a convention that resulted in the 1790 Constitution, creating a government following the federal model, with a government and 2-house legislature. The Constitution was declared adopted without any popular vote to accept it. This Constitution stayed in effect until 1838. In the mid-1830s, a reform movement led to the passage of an act in 1835 to call a constitutional convention that the electorate approved. The convention met in 1837, chiefly hoping to limit the appointive powers of the governor. Judicial reform also restricted the term of office of Supreme Court justices to only 15 years. The Constitution was approved by the electorate by only 1,212 votes. With Jacksonian democracy, 2 later amendments, the election of judges in 1850, and absentee balloting for soldiers during the Civil War in 1864 took place. Also, an 1867 amendment provided for a bill to obtain a single subject and that the title should express the purpose of the bill. Population distrust of the legislature caused by large populations, especially the Railroad's control over the legislature resulted in the call for a new convention in an 1872 act. It's usually cited that the legislature passed 475 general laws and 8,755 special or private laws between 1865 and 1873. Although the influence may be true, the actual problem is that there was no general corporation law. So anytime any corporation, bank, turnpike, railroad, etc., needed a change in their structure, an act of the legislature was needed. A General Incorporation Act was then passed in 1874, and the amount of special or private legislation dropped precipitously in the number of statutes passed in succeeding years. The 1874 Constitution also provided for a legislature double the size, the belief being that a larger legislature would be less prone to bribery. Also, revisions were made in Article 3 on how legislation should be written. For instance, the title of the act should reflect the contents of the act and the 3 readings of the bill on 3 different days. This convention's actions were approved by the electorate, and the 1874 Constitution was created. Some of these changes were carried over into the 1968 Constitution. There were amendments to the 1874 Constitution passed over the decades, and 6 failed attempts to call constitutional conventions. Governor Scranton's and Schaefer, with the assistance of Pennsylvania Bar Association, in the 1960s gained acceptance to amend the 1874 Constitution through a series of amendments between 1965 and 1967, and with the calling of a limited constitutional convention from December 67 to February 1968, it resulted in further amendments adopted by the electorate in 1968, created the 1968 Constitution we are now living under. The act creating the Constitutional Convention and limiting the topics discussed at the convention was passed in one act. The 4 major categories included legislative reapportionment, judiciary, taxation, except for the uniformity clause, and local government reform. The convention carried out its task and did not go beyond the statutory limit, and the amendments created were approved by the electorate in April 1968. Since 1968, there have been 45 amendments to the Constitution. Probably 2 of the most important were the environmental provision of Article 1, Section 27, and the Equal Rights Amendment is Article 1, Section 28. There have been more than 2,000 bills amending a wide range of articles and sections and adding sections to the Constitution, but few have gone past the first reading. And I got that total from counting all of the topical indexes for each General Assembly. It has been 50 years since a review of the 1968 Constitution has taken place. Beginning in 2006, there's been a steady call for the creation of a constitutional convention to review the current Constitution. Along with the introduction of legislation in 2006, several outside groups began to become interested in the topic. These efforts resulted in the publication by the Civic Research Alliance of the Citizens Guide to a Modern Constitutional Convention in 2009. And I should point out it was co-authored by another law librarian, a friend, Mark Padvia, the associate law librarian at Dickinson Law School and now at the College of Law, West Virginia University. And I helped on the paper, on the book, just doing the bibliography, updating that. The Pennsylvania Bar Association created a task force in 2009 to review various aspects of the Pennsylvania Constitution that led to the creation of a Constitutional Review Commission to do a complete study of the need of the Constitutional Convention. The Commission's activities are available at the Bar Association website. The report published in 2011 was never adopted by the PBA House of Delegates, but the report reflected hundreds of hours of work by the commissioners to provide an unbiased report. Like the Citizens Guide, it too recommended a limited constitutional convention or amendment through Article 11 to address various issues. In 2010, the Pennsylvania Bar Institute published a continuing legal education book, Should Pennsylvania Have a Constitutional Convention? And that included sections republishing part of the Citizens Guide and the background on the origins of the PBA task force by the CRC chairman. Looking at the more recent 15-year time period from 2005 to 2020, there have been 31 bills introduced into the General Assembly to hold constitutional conventions. Bills are broken down by title and year, as I've given below. Since there may be from 1 to 3 bills proposed during the 2-year session for the specific bill title, they are listed in parentheses. Some of the titles are just listed as Constitutional Convention Acts. Some are listed as Citizen Constitutional Conventions. Some are listed as Limited Constitutional Convention Acts. So it does vary in terms of the title. The main differences that you see here is that the Citizens Constitutional Convention Acts usually leave open amending all of the articles of the Constitution except for Article 1, the Declaration of Rights. The other constitutional bills usually provide for a limited scope of review of just certain articles. Breakdown of these acts results in the chart of number of articles and sections listed. And as we see here, Article 2, Section 8, dealing with compensation, and 16 dealing with legislative districts have 15 times being amended. Article 326, extra compensation prohibited, as 14. Article 2, Section 4, dealing with sessions, and Article 3, Section 13, votes denied members, have 10. A smaller number of proposed changes affects Article 3, Section 14. 7, Article 4, Section 4, with the Lieutenant Governor having 6 references, and Article 4:14 having 5 references. And then under Article 5, Section 10, 17, and 18 all have 4 references. Of the current 2 bills, although the formatting is slightly different as to section numbering, the contents are almost the same except for the following provisions, which may be important considerations between the 2 houses. First, the Senate bill provides for a calling of a convention every 20 years. There is no provision for that in the House bill. At least 14 states have a section on calling constitutions either every 10 years, 5 states, 16 years, 1 state, or 20 years, 8 states. And another 6 states have provision for the legislature to summon a constitutional convention. And this is from the Citizens Guide, Appendix G. Such a provision would remedy the 50-year hiatus we currently display, but even if the section were adopted, it would still need the public's approval to hold a convention. Second, the number of delegates to the convention. 1967-68 convention included the members of the preparatory committee to sit as members. The preparatory committee was made up of most of the officials of each of the houses. The House bill does this, the Senate bill does not. The 13-member distinction may be important when you are providing for majority voting on issues. Robert Montagna, in his PhD dissertation, Pressure Group Influence on the Pennsylvania Constitutional Convention of 1967-68, done in 1974, found, quote, some delegates believe that much more pressure was exerted by some of the political officials of the convention and by the legislators who were appointed delegates to the convention than by any organized pressure group, unquote. Third, the House allocates $200,000 for the preparatory committee to spend on the convention. The Senate bill has no specific figure, nor is there a total amount allocated for the convention. Both bills, however, provide for donations from the public. The Citizens Guide from 2009 provides that in 1967, the preparatory committee was allocated $100,000, which in 2009 dollars would total $645,000, and $2,500 for each delegate to cover their expenses, of which there were 150, would now be $2.4 million. Adding in travel expenses, it was estimated to cost more than $3.5 million without adding costs of facilities, equipment, paid experts and consultants, and that raised the cost to almost $10 million. These figures are 10 years old, and so even these figures are out of date and would be even higher. Interestingly, the proposed bills from 2008 to 2017 allocated $20 million for the entire convention, which neither current bill provides for here. On the other hand, the Citizens Guide suggested calling a virtual convention. And in favor of that, it was felt that much of the preparatory committee's work could be done virtually. Public internet interaction could increase outside participation, and there would be reduced costs in transportation, lodging, per diem costs, support staff, and expert costs. It would also lead to fewer days for the delegates to be away from home or business. Some of the contras or cons, like delegates not being computer literate or have equipment or omit, or people did not have access to computers and would have to go to libraries, colleges, or schools in order to access the convention, or costs associated with hardware, communications, and technical support is probably less important today because of the increased access to computers and advances made in technology today. Fourth, although the bill provided for a July 1st to November 1st sittings, the preparatory committee may not have sufficient time to prepare its own materials if it starts right after an approval vote by the electorate in a primary election, either April or May, or not until a general election in November. 1967, the preparatory committee met from May to December when the Constitutional Convention began. This is 7 months rather than 1.5 months to 3 months allocated under the current bills. This would be a mistake if not enough preparation time takes place. Montaigne also writes that the preparation committee, quote, did an outstanding job in its work of supplying the delegates with information concerning the nature of Pennsylvania governmental institutions and research materials on constitutional revision, unquote. Fifth, both bills provided for the registration of lobbyists, but there's a small difference in the penalty assigned to a lobbyist who breaks the law. The House bill states $500 fine, and the Senate bill, the fine was based on a misdemeanor charge. Earlier bills called for higher fines and even felony charges against the lobbyists. Interestingly, as a side thing, there was one bill that had $100,000 charge against the members if anyone was bribed by a lobbyist. Lobbyists will play a somewhat different part in the deliberations, again, as Montaigne concluded, that, quote, interest group activity was rather moderate and well executed, and in some cases could be termed constant, unquote. Sixth, there were 4 major categories broken down into 30 proposals addressed in the 1967-68 convention that were addressed within the time frame of the 3 months. Under the current proposals dealing with the various sections of Articles 2, 3, 4, and 5, it appears that a limited convention could fulfill addressing these issues within its allotted time frame. Seventh, if the convention resolution can be passed before the end of this year in both houses, the earliest date for a public vote would be May 2021 if we're approved in the new assembly during the first month to make it available at the primary, or more likely the general election in November 2021. So the earliest convention will meet is sometime in late 2021 or early 2022 with an electorate vote in the primary or general election in 2022. If a bill is not passed during the session, it will take another 3 years before the bills can be approved by the next 2 general assemblies, the 2021-22 or 23 and 24 assemblies, before it can even be presented to the electorate for a vote upon its acceptance or rejection, at least by 2023. Eighth, as stated previously, there would have to be widespread public relations to inform the electorate of the need for reform. Leaders of both political parties would probably have to support the measures. In conclusion, the current bills follow previous bills providing for the establishment of a limited constitutional convention, creating a preparatory committee to set up the convention, providing for the selection and election of members of a convention, and providing for the specific sections of the Constitution to be reviewed. The time frame is limited to adopt the current bill by the end of the year and appears to be a somewhat difficult task to achieve. The Senate bill to call a constitutional convention every 20 years to review the Constitution may be a useful tool for future constitutional reform that does not place a burden on the legislature, since the electorate will decide if it should be called. This could be a single proposal for reform separate from creating a limited constitutional convention. On the other hand, the passage of individual proposals on each article rather than calling a limited constitution may be able to obtain the desired results of those who support the calling of the convention. For instance, the 4 individual proposals just passed by the Assembly can be adopted early next session and appear on the primary ballot in May. I just saw this in the paper 2 weeks ago. There were 4 proposals being advertised. I hope I have supplied some background information useful for the committee. Thank you for giving me the opportunity to address the committee on this important constitutional issue. Thank you.
Thank you, Dr. Fishman. As the son of a librarian, I can only imagine the amount of time that you've spent on this issue, and I thank you for that. Let us turn now to Senator Kristen Phillips-Hill.
Thank you, Chairman Argel, and thank you, Dr. Fishman. Your testimony was illuminating. Again, as I said earlier, in welcoming everyone to this hearing, Senate Bill 1035 and House Bill 611, both pieces of legislation give Pennsylvanians that much-needed voice. And as we heard Dr. Fishman testify, constitutional conventions in Pennsylvania are not a new novelty, but they are rare as of late. As he testified, the planning for the last constitutional convention began the year that I was born. And the last constitutional convention occurred before Neil Armstrong took one giant leap for humankind. And the voting age in Pennsylvania was still 21. So to say that we are overdue, I think, is a great understatement. This constitutional convention would be limited in nature to look at the very issues that many of us have campaigned on and supported throughout our tenure. For one reason or another, these reforms cannot make it across the proverbial finish line. The scope of the convention would be established as follows. 150 members would comprise the convention, with voters in each state senatorial district electing 3 individuals. These individuals would be required to obtain 100 signatures to have their name appear on the ballot and meet certain age and residency requirements. Most importantly, no member of the General Assembly, the governor, lieutenant governor, statewide row officer, or judge can participate in the convention. A majority of the 150 members is required to make recommendations to the electorate on these subjects and these subjects only. Under Article 2, the following sections. Section 3 relating to term limits and changes in the length of terms of members of the General Assembly. Section 4 relating to the General Assembly's status of being a full-time or part-time legislature. Section 8 relating to compensation for the General Assembly. Section 16 relating to the number of seats in the General Assembly. Under Article 3, the following sections. Sub-Article A relating to amendments of legislation on third consideration. Section 13 relating to prohibitions on voting. Section 22 relating to no-bid contracts. Section 24 relating to spending without an enacted budget in place. Section 26 relating to pension and cost of living adjustments. Under Section 3, the following associations, I take that back, Section 4. Under Section 4, the following. Section 4 relating to the office of Lieutenant Governor. Section 14 relating to simultaneously serving as a Lieutenant Governor and member of the Senate of Pennsylvania. And under Article 5, the following sections. Section 10 relating to independent review. Section 17 relating to work outside of court service. Section 18 relating to Supreme Court involvement. And let me be crystal clear. This convention shall not include any changes to the Declaration of Rights of the Constitution of Pennsylvania. The convention shall come up with at least one question for the voters to decide on to each of the above-mentioned sections. This process, as Dr. Fishman discussed, could occur every 20 years. However, whether the state holds a convention is predicated on the voters. Over the last several years, the General Assembly has debated ad nauseum over many of these matters. Should the House be reduced to 153 seats? Should the Senate be reduced to 45 seats? Should the legislature reject the automatic cost of living adjustment? Should the state have a plan in place to pay for its budget? Many of us up here and those who are online are probably nodding their heads. But we need 26 votes in the Senate, 102 votes in the House, and the signature of the governor. And these issues predate our time in the General Assembly. And while you may find consensus on these pressing issues among committee members, we still cannot reach consensus to advance these much-needed government reforms. So Representative Ryan and I say, let's give it to the people to decide. The people get to vote on their members to this convention. The people get to vote on every item to be suggested from this convention. And to the people of Pennsylvania, this is a way to give you the power that you have not had in 50+ years. So since the last convention, we figured out how to put a man on the moon, but we can't agree on certain aspects of the size and scope of our state government. And if the General Assembly and the governor cannot come to agreement, then it's time to change that and to take an honest look at handing the reins over to the people with Senate Bill 1035 and House Bill 611. Thank you, Mr. Chairman.
Thank you, Senator. Representative Frank Ryan.
Mr. Chairman, thank you so much, Senator. It's a pleasure working with you on this bill, and it was an honor to serve with you in the House of Representatives as well. Senators, thank you for your time today. And Dr. Fishman, again, I truly appreciate the great words that you had earlier. Rather than trying to repeat some of the things, I'd like to just focus a little bit on some of the areas of the two bills that are a little bit dissimilar in the process, but I want to just give you a little bit of a background that I think might be a little bit useful. As Senator Kristen Phillips-Hill mentioned, we've been trying to get a number of issues across the finish line. And when we run into different areas of resistance, I think the most recent coronavirus crisis really brought to the forefront many of the issues that many of us have been expressing concern about as citizens. And I'm relatively new to the legislature, although relatively old in life. When the first Constitutional Convention came around, I was working very actively with Thomas Jefferson and Benjamin Franklin, whereas my dear colleague to my right was just a little bit, just starting grade school in the 1970s, I think it was. And so it's a scary thought. But what's got me concerned is that we are on a collision course. And the issue with the Emergency Powers Act of 1978 and the Supreme Court's interpretation of some of those rules and regulations have led me to conclude that the balance in Pennsylvania has decidedly moved away from citizens totally. It's actually moved away from the legislature as well. And it's moved decidedly in the hands, in this case, of the governor and the Supreme Court. And that's not a political comment. It means to say it was never intended to be that. It was intended to be a balance of power of three co-equal branches of government that we've lost that. And a lot of it came about because of a crisis in 1955 where we gave emergency powers for different health emergencies and declarations. You know, if you had asked me 2 years ago, did I think that this Constitutional Convention was going to be probably the most important thing that we would work on, I would say we might not even get people to look at it. But if there's anything I'm hearing on a regular basis now from citizens, is this fear and concern about who is actually in control, and can a few people grab power and suspend the right. So one of the issues that I do want to mention to you, the biggest objection that came about prior to Senator Kristen Phillips-Hill and I getting involved with prior advocates of the limited constitutional convention was the fear that Article 1, which is a declaration of rights of the Pennsylvania Constitution, could be interfered with. And we've gotten complete assurance that it cannot be. It's in the bill, number one. But even more importantly, there are prior legal precedents in the Supreme Court that we've been shown that indicated when people attempted to deviate from a limited constitutional convention that they were not successful being able to do that. And we believe the controls that are in the bill will prevent our, for lack of a better term, our Declaration of Rights. Typically, the one I hear the most is the right to bear arms. I do want to caution those of us that are strong advocates of the Second Amendment of the U.S. Constitution that under the Emergency Powers Act in 1978, from what I've seen, the way the Supreme Court has acted, it's not completely beyond the realm of probability that your constitutional rights to bear arms are not already at jeopardy until we get this under control. So I want to say that in order to raise the specter of concern. Just relative to certain differences, the Bill 611 has got the same 150 requirements for delegates, 3 from each one of the senatorial districts. On the House Bill 611, we have an additional 13 members that we've put in that are basically members of the leadership team of the Democrat Party and the Republican Party, or whomever is holding those positions. It would be the lieutenant governor. If it would be an independent, it would be an independent. It would be the Speaker of the House, the President pro tem of the Senate, the majority leader, minority leader, the whips of both parties, et cetera, a total of 13 additional. I felt that was necessary to provide some degree of additional continuity. They are ex officio members, certainly not enough to sway the discussion and the direction. But I will tell you the differences between the bill are not that fatal that I think it would stop it. In other words, if Senator Kristen Phillips-Hill came to me and said that the policy committee in the Senate said that they felt that that was not appropriate, it could easily be pulled out of the bill. My concern is, anytime I've gone through doing turnarounds of financially troubled entities, which is what I did before I got elected, having that corporate knowledge base of what exists and what doesn't exist, why certain things are doing the way they are, would tell me that having that repository of knowledge could be a fairly useful thing at times, and they're not a large enough number to sway the actual deliberations. And I'll just give you an example. If you had talked to me 2 years ago or 3 years ago, I would have said absolutely, unequivocally, term limits is the absolute way to go. And I still support that. I'm supporting the bill in the Pennsylvania House to limit the term limits. However, I would also tell you that if you don't have controls on that, you might have just surrendered your entire government to the bureaucratic processes of the state, which could be equally as damaging, something that we need to take into consideration as we do this. The reason for the Constitutional Convention, and I'll conclude, in my mind is this. In my travels as a United States Marine, I had the opportunity to see the Loya Jirga in operation in Afghanistan. And that had been around for literally a millennium. And it's a grand council that gets convened periodically to resurrect and restructure themselves. And I thought, you know what? That's really reinforcing the need that we might need to periodically take a look at things in its whole. We had 4 constitutional amendments presented in the House of Representatives and the Senate within a week or two, and all 4 of them were approved. And my apprehension is that sometimes it's a good idea to have the entire document looked at for Articles 2, 3, 4, and 5, which is the legislative branch, the executive branch, and the judicial branch, so that we can holistically look at those changes that are necessary and let the citizens who elected us decide what they would like to see. Mr. Chairman, thank you.
Thank you very much, Representative Ryan. We now turn to Ken Quinn, who traveled here from Maine, so you definitely are committed, Ken, on this as the Northern Regional Director for U.S. Term Limits. Mr. Quinn, please begin.
Thank you, Chairman Argel, distinguished committee members, senators, and Republicans. I'm here today to testify in support of SR 377, not only on behalf of our organization, but also on behalf of the American people. 82% of the American people want term limits on Congress. This has been an issue that has been going on and raging for decades. Back in the 1990s, 23 states passed laws to impose term limits on their own congressional delegations. Unfortunately, in 1995, the U.S. Supreme Court, in the case against us, U.S. Term Limits versus Thornton, overturned all of those state laws and said the only way this can be accomplished is through an amendment to the U.S. Constitution under Article 5. And I want to thank Senator DeSanto for introducing this very important reform here, and so we appreciate that. Now, in regards to proposing amendments, there's only 2 ways to propose amendments to the U.S. Constitution. It's either by 2/3 of both houses of Congress may propose an amendment, or upon the application of 2/3 of the state legislatures may apply for an amendment, and then Congress is forced to call a convention to allow them to meet to propose that amendment. Now, we don't have a lot of faith that Congress is going to propose this amendment by the 2/3 needed. To give you a little history, I love history. Congress has introduced 12,000 amendments since 1789 to the U.S. Constitution, 12,000. The states, during that same period of time, have introduced 0 under Article 5. And so it's time that we have the states, and I do appreciate, Chairman, you sharing the Declaration of Independence and the consent of the governed. When we feel it's time to alter our government, we feel that is exactly the principle Article 5 allows us to do, and it's time that the state legislatures use the authority granted to them under Article 5 through this process. And I'm here today asking you to please do that by supporting SR 377 on behalf of the American people. Now, term limits are nothing new. Back in our founding, this used to be referred to as rotation of office. As a founding principle of our country, in fact, one of your own, Ben Franklin, one of my favorite framers, he understood the danger of allowing people to hold power for too long. And in Pennsylvania's Declaration of Rights of 1776, which he helped to draft, Article 6 says this, quote, that those who are employed in the legislative and executive business of the state may be restrained from oppression. The people have a right at such periods as they may think proper to reduce their public officers to a private station and supply the vacancies by certain and regular elections, unquote. And then contained in the first Constitution of 1776 in Section 8, there is term limits. Quote, no person shall be capable of being elected a member to serve in the House of Representatives of the freemen of this Commonwealth more than 4 years in 7, unquote. Now, to tell you the truth, we all know and feel the oppression from Congress, and so we're asking you to stand with the American people to break this chains of oppression by removing the power from Washington, D.C. and bringing it closer to the people. And that's what term limits will help to address. That's just one of the reforms that term limits will do on behalf of the American people. A congressional term limits amendment will also provide fair and competitive elections, making it possible for ordinary people to run for office. A lot of good people don't even bother to run for office because they know they can't raise the millions of dollars it takes to beat an incumbent. It will allow more people to participate from a variety of backgrounds in our government so that we can have different eyes to examine the problems that we're facing. It will give us, the voters, more choices at the ballot box and will help to increase voter participation. I hear all the time people, they don't want to vote because they're tired of, quote, voting for the lesser of two evils. And so this will help to improve our voter turnout. Term limits will send new people with fresh ideas to fix the problems that Congress has refused to fix or address over the decades. How many years and decades have we been hearing about a balanced budget amendment and the immigration crisis, the healthcare crisis, the spending crisis? It's up to the state legislatures to help deal with these things, with term limits being the #1 issue to get us going in the right path. Term limits will also help reduce big money that's being spent in not only elections but also in politics, because currently 97% of all corporate PAC money is spent and given to the incumbents, not to the challengers. And lastly, this is the will of the American people. Over 82% of the American people across the parties want this. It polls high at 89% Republicans, 76% Democrats, and 83% independents. I can't think of another issue in this country today that can bring both sides together as much as term limits for Congress. Now, another lesser-known framer from Pennsylvania, from Philadelphia, who I greatly admire, I have dubbed him the Term Limits Convention hero. His name is Tench Cox. I don't know if you know Tench Cox, but he was a businessman in Philadelphia. He is probably responsible for the Second Amendment. He wrote many articles defending the Second Amendment before it was added to the Bill of the Constitution, and so we owe him a great gratitude for that. This is what he said about Article 5. He really understood the Article 5 process and the reason for it. Now, this is the first person I have found that has suggested an Article 5 convention for term limits. This was July of 1788, 1 month after the ratification of the U.S. Constitution and before the federal government even began. He said this, quote, you have been told also that after the new Constitution takes place, the officers under it may become perpetual. Now, it is fully and absolutely secured that no representative, senator, president, or vice president can continue beyond a stipulated time. And if the people think that time too long, they can get their state legislatures to apply for its being shortened. If 9 legislatures out of 13 apply this year or 10 years hence, there must be a convention called to consider that point. And so that was the first reference to a term limits convention that I was able to find. It's interesting, when Thomas Jefferson read the Constitution for the very first time, he sent a letter to James Madison, and he said, there's 2 things I don't like about it. You did not include the Bill of Rights, and the second thing I greatly dislike is you abandoned rotation of office, term limits, especially for the president. Well, Mr. Jefferson, we did get the Bill of Rights shortly thereafter in 1791, and eventually we did get term limits on the president. The 22nd Amendment, ratified in 1951. Our organization, we commemorate that day. It's National Term Limits Day, and we feel if term limits are good enough for the U.S. president, they're good enough for members of the House and the Senate. Tench Cox, in closing his pamphlet that he wrote, he said this, and this is what I love most about the Article 5 convention process, quote, "It must therefore be evident to every candid man that 2/3 of the states can always procure a general convention for the purpose of amending the Constitution, and that 3/4 of them can introduce those amendments into the Constitution, although the President, Senate, and Federal House of Representatives should be unanimously opposed to each and all of them. Congress therefore cannot hold any power which 3/4 of the states shall not approve on experience," unquote. This was a check that the framers gave to the states against a runaway federal government, and this is how we can bring the power back. This is how U.S. state legislators can solve a lot of our problems nationally, and number one being the power of the incumbent party. In closing, I would encourage you, I've included some documents, and I would just want to share a little personal background. I used to be adamantly opposed to an Article 5 convention. In fact, I used to try to convince legislators never, ever do this. It's a runaway, it's a con, we'll lose the Constitution. And the reason I was saying all that is because I was getting my information from an organization that opposed it. And what happened for me is I started to question, why do I oppose something that's in the Constitution? Well, long story short, I did my own research. I ordered Madison's notes from the Federal Convention. I ordered the Federalist Papers. I started reading on my own and could not believe it, but my eyes were opened. I never understood why they put this in the Constitution. When I did, I no longer was afraid of it. I embraced Article 5, and now I am an advocate for it because this is one of the ways the states can solve our problems. And now, what I want to do in closing is just address some of the opposition points I'm sure you have heard for quite a while now. And this is what these documents are going to cover, so please review them at your own time when you have it. Number one, I went through the notes at the convention, and I highlighted every single substantive discussion on the amending provision during the Federal Convention of 1787. This proves beyond a shadow of a doubt that they understood a convention, an Article 5 convention, is limited to what the states apply for. It's limited to the amendment that's applied for by 2/3 of the state legislatures. Number two is that immediately after they approved adding the convention back into the amending provision on September 15th by a unanimous vote, a motion was made by Roger Sherman of Connecticut to give Article 5 the same authority as the 1787 convention in Philadelphia, a con. It was rejected. The delegates voted that down. They voted against this being a con. Okay, that's in September 15th. I never knew that. The second thing is this. Article 5, there's two different types of conventions, and I provide you information on that. And Constitutional Convention is a new social compact, requires unanimous consent. Article 5 is just proposing an amendment. And so there, on this document here, I compare the two different types of conventions so you can see the difference. The framers were very clear on that. In fact, Alexander Hamilton addresses the two types of conventions in Federalist 85. And one of the things you hear all the time is the runaway convention, okay? It will run away like the 1787 convention ran away. Let me just briefly share what you hear, that Congress called the 1787 convention to solely revise the Articles of Confederation. And what happened? The delegates arrived, they threw out the articles, and they drafted a new constitution. Simply not true. That convention was not called by Congress. It was called by the state of Virginia. Virginia called it based on the recommendation of the Annapolis Convention the previous year. The delegates at the Annapolis Convention, they did not have a quorum, and what they did was they recommended to the states to have a convention in Philadelphia for this purpose. The appointment of commissioners to take into the consideration the situation of the United States, to devise such further provisions as shall appear to them necessary to render the Constitution of the federal government adequate to the exigencies of the Union. That was the purpose of the call. That is what Virginia called the 1787 convention for. The states sent their commissioners, giving them that authority to do exactly that. They were not limited to solely revising the Articles of Confederation. That is what that straw man argument comes from, by not knowing our history. Now, I encourage you, please read Federalist 40, because James Madison expressly wrote that to deal with the charge, the false charge, that they exceeded their authority. There's another quote you might have seen with James Madison trembling at the thought of an Article 5 convention. The opponents use this one all the time. They lift it out of context. I provided you the entire letter that he wrote. He was answering a request. George Tuberville asked him, hey, so what are your thoughts on what New York wants? New York wanted a second constitutional convention. The Anti-Federalists were strong in New York, and Madison did not want to have a redo, okay? The government had not even begun yet. And so where that quote comes from is taken from a letter where he is saying, no, we do not want a second constitutional convention. Let's have Congress propose the necessary amendments, because right now, during that time, the passion between the two sides is just, it was not the right time. He was not against an Article 5 convention. He just thought the most expedient way to address the Bill of Rights specifically would be through Congress at that time, okay? I encourage you, read the letter in context. You'll see what he's talking about. He's not fearful of an Article 5 convention. He just didn't see that they could get enough states to agree at that time to even call one. And in closing here, promise, to me, the best evidence proving that it's limited is Virginia was the first state to apply for a convention. 1788, they passed it. In that first Congress, in May of 1789, over 50 members of that first Congress were either delegates to the Federal Convention or they were delegates to their state ratifying conventions. They thoroughly understood Article 5. And when you read the debates from in Congress, it's clear that they understood they had to have 2/3 of the state legislatures apply for the same amendment in order to call the convention. It's limited to what the states agree to, and I highly encourage you to read that as well. With all of that information, the myths that are out there, all of the questions about this process can be answered just by going back to original sources. So I thank you for your time. I encourage you to please support SR 377, and I'd be happy to take any questions that you might have.
Thank you. Thank you very much, Mr. Quinn. Before I turn it back to our host, Senator Kristen Phillips-Hill, I want to note that Senator Yaw is also joining us online from North Central Pennsylvania, and Senator Judy Ward, who represents the Altoona area, has also joined us online. Senator Phillips-Hill.
Thank you, Chairman Argall. Mr. Quinn, thank you. Here in York, we believe that we're a historically edgy kind of place, and we're very proud of the role that York played in our constitutional history. And if you have a chance before you head back up to Maine, you could pop downtown and check out the restored place where all of that work took place. And I have a few questions for you, but I would like to turn my attention to Dr. Fishman. we have been very fortunate. We had testimony presented to us by the National Conference of State Legislatures. They were not able to attend today. But in the documentation that they sent to us, they noted that Pennsylvania is one of only 8 states that does not have a specific article or section about a constitutional convention found in its constitution. Do you believe that that is something that needs to be addressed as we embark on this process?
Okay, can you hear me now?
Yes.
Okay, thank you. I'm still getting used to this. I'm not sure why they never included that in any of the constitutions. Can you repeat the question again, how you stated it?
Well, in the National Conference of State Legislatures testimony, they provided a document entitled Constitutional Provisions Amendment of a State Constitution by Convention, and detailed the requirements under different states' constitutions for calling a constitutional convention. And in that documentation, I noted that Pennsylvania was one of only 8 states that did not specifically have a provision, an article, or a section about constitutional conventions found in its state constitution.
Right. So I haven't seen it before. I don't think there was discussion in the 1967 Constitution. The amendments, the Article 11 amendments have been around since 1874. And it's up to the legislature at this point to provide for a provision in the Constitution. It would be the same as introducing initiative and referendum. There's another method to introduce constitutional amendments. It's not a part of the Constitution, and it's something that the legislature would have to approve.
Thank you. In your testimony, you did a, I think, really good job of laying out the differences between the Senate bill and its House companion bill. First, with regard to the provision that calls for a convention every 20 years. There are some states that call for a constitutional convention every 10 years. I believe one calls for it every 16 years. There is no such provision in the House bill. Do you have any thoughts on whether 20 years is too long, if 10 years is better, perhaps every 4 years? And you did note in your testimony that it still needs to be adopted or approved by the public.
I think, again, it varies from state to state. Even though the provisions have been in the Constitution, in their state constitutions, it's still been left up to the electorate to vote on it. And in other states, even though they have the section in there, the public still has not approved it. I think that happened in New York. I think it happened in Maryland in recent years. And so it's really a problem because you just don't know how the electorate is going to vote on that.
And one more question before I turn it over to my distinguished colleagues here today. There is a difference between the number of individuals serving on the convention. The House bill has the 13 members that are elected officials serving in an ex officio capacity. The Senate bill does not. In terms of best practices, what do you see in other states and what do you recommend?
Even though they're ex officio, they're still active members of the convention. The 1967 convention had these ex officio members, fully participating in the vote and in the discussions. I am I don't know enough about the other state constitutional conventions, to be honest with you, to know if the members of the legislature were also part of the constitutional conventions. I just don't know that, so I'm sorry.
Well, thank you. And if I may, Chairman, have a few questions for Mr. Quinn with regard to the term limit resolution. So in your testimony, you indicated that there are two ways that term limits could be enacted. The first is that Congress could pass a constitutional amendment, which would then be approved by, well, would need to be approved by 3/4 of the states. And you said that that's probably highly unlikely. And then the other means is to convene a constitutional convention as, as this resolution before the General Assembly has envisioned. So in doing a little research, came across a U.S. Supreme Court case, and in 1995, in U.S. term limits versus Ray Thornton, the Supreme Court indicated that states could not impose an additional qualification on candidates in federal office. What has happened subsequently? Has precedent changed since that case?
No, what the court ruled was the states could not do it, the legislatures themselves could not do it, nor could the people at the ballot box do it. The only way in that, what that ruling said this can be accomplished was under Article 5. So Article 5 either by Congress or by the legislatures calling a convention. So it can only be done that way. In the 1990s, the states did it individually. Like, I'm from Maine. The people of Maine voted to put term limits on their own members of Congress, and that's the types of laws that were overturned.
Okay.
And so that still has not changed.
So individual states can't impose those term limits on their own congressional members. It has to be done through an Article 5 convention and apply in a uniform manner across every congressional delegation in every state.
Correct.
Okay, very good.
Now, there is a glimmer of hope that, I don't want to get into the weeds here, but there was a unanimous decision by the court recently in regards to presidential electors. And the court seemed to have flipped on whether or not states have the authority to qualify electors, which means if they can, perhaps this could be revisited, because back in 1995, they said they couldn't. And so we're not addressing the Supreme Court decision, but yes, the way it is as it stands right now, the only way we can do this is through an Article 5 convention and have the states propose it.
And I guess just one last question. In reviewing this measure, I felt a certain sense of hypocrisy as a state legislator who would not currently be under a term limit, other than a self-imposed term limit, right? To impose one on a member of Congress while not imposing one on members of the General Assembly as well. Do you have any thoughts on that?
Well, for the people, they can easily meet with their state representatives and senators. Members of Congress are out of touch. We no longer see them once they go to Washington, and so there's such a huge disconnect, whereas at the state level, that disconnect does not really exist. I could go visit my state senator or my rep. I could see them in their district where I live. I can go to the State House to see them in person, meet with them. And so the issue there is the American people are so adamantly in favor of a congressional term limits that this is something that they've been wanting for decades. At the state level, it's different. It's much easier to vote a incumbent out at the state level. It doesn't require millions of dollars. And so those races can't compare to the types of races at the federal level. And so it's not comparing apples to apples, you know what I mean? It's something that we feel, now granted, I'm with U.S. term limits, so we believe term limits should be at every level of government, and I appreciate it being addressed in the other resolution for the Pennsylvania Constitution, and we will help you with that if any way that we can. But it really is different at the national level, and that's what the American people want desperately, is to have that done.
Thank you very much. Mr. Chairman, thank you.
I'm curious to follow up on Senator Phillips-Hill's questioning. How many states have done what you've suggested with the Article 5 convention so that this process could begin?
Yeah, that's a great question. The history of Article 5 applications, there's been over 400 of these submitted to Congress in 1789. And the reason the convention's never been called is because the 2/3 have never been reached. It's come close a couple of times. Currently, our single subject application has been passed in 3 states. There's another 12 states that have passed applications that contain congressional term limits in it. And so technically, 15 states have applied to Congress through the Article 5 process for congressional term limits.
Can you give us the list of those 15? I'm curious. Red, blue, purple, east, west, north, south. I'm looking for patterns.
I don't have the list in front of me, but, you know, Florida,
could
Alabama,
provide that,
Missouri have passed ours, the
Okay.
single subject. Arizona, Tennessee, I'm drawing a blank, but
Okay.
I can give you that
All right.
list. Yeah.
But they're not all, they couldn't easily be categorized into one box, in other words, is what you're telling us.
Well, the other one has more of a broader subject matters.
No, I'm sorry, the states themselves.
No,
It's not
no.
like they're not all New England states, or they're not all
They're not.
southwestern states. And okay, all right, that's what I'm looking for. And if you can provide that information to the committee staff, that would be very helpful. Also, in terms of, it's apples and it's oranges, but there are some similarities. Of course, many states have pursued their own version of term limits at the House and the Senate level for their own legislatures, primarily through initiative and referendum. I'm curious if you're aware of any research that would indicate that 10 years after those term limits were imposed in California, or name the state, what kind of changes did the people in those states see? Was it indeed better? Was it worse? What was the effect?
Well, the world did not end. One report I like to reference is, I believe it's the Mercator report, fiscal ratings of states, and it was a 5-year study. The top 4 out of the top 5 states that have the best fiscal ratings have term limits. None of the ones at the bottom have term limits. And so I'm not saying that term limits made it fiscally better than the others, but what I am suggesting, and I think can make the point, is that term limits did not harm the state in any way. So in Maine, we have basically a rotation where a person can serve in the House, then go to the Senate, and then they go back and forth. It's not a lifetime. For an example, Michigan has probably the strictest term limits, 8 years. And one thing about the people, which is the consent of the governed, is that whenever they are given an opportunity for to impose term limits, they want them. And when they find out that their current term limits are trying to be removed or extended, they oppose that. And so when it comes to the effect for the people, they appreciate limiting how long somebody can hold a seat of office.
Other questions, comments for the good of the order? Please, Senator Phillips-Hill.
If I may, in a sidebar conversation, because we're discussing both of these measures at one hearing, that these are actually 2 separate measures that we're discussing here. We're talking about a state constitutional convention in the legislation that Representative Ryan and I have sponsored. And then with regard to term limits specifically, that is an Article 5 convention at the federal level, and they're two separate and distinct proposals, just in case folks at home are following along and they may be intermingling the two. One addresses the state constitution, one addresses the federal constitution. So just wanted to get that on the record. Thank you, Mr. Chairman.
Duly noted. Other questions, comments, please? Representative Ryan.
Mr. Chairman, if I could, and to respond to Dr. Fleischman, relative to one particular issue, we have a separate co-sponsorship memo in the House of Representatives to incorporate within the Pennsylvania Constitution a recurring constitutional convention right now it says 20 years. We're getting some pushback on that. So it will actually accommodate the Senate bill itself as well, but under two separate bills that we've done it that way. And again, those differences could be easily modified and brought into one.
Anyone else, please? Okay. Senator, let me give you the last word.
As we said earlier, and I think Representative Ryan's opening remarks and testimony really succinctly stated that we have seen an incredible amount of government overreach, and we are looking to give the power back to the people, and really want to thank those who have been able to participate in this hearing, to Mr. Quinn and to Dr. Fishman. Thank you so much for your testimony, and to the chairman, thank you for bringing this hearing to Dallastown. And as I said earlier, York has had a very special place in our nation's constitutional history, and I think that we have been very blessed and very fortunate to have these documents guide us through some of the best of times, but also some of the worst of times. And they are incredible documents, and we recognize that there may be some small things that need to be done to enhance them as they move forward into the future. And so I thank you again, Mr. Chairman.
Thank you. Thank you, Senator. It's a very timely topic. While I think, as noted, some pieces of this discussion feel a little bit like a graduate seminar in political science or history. When Representative Ryan mentioned the ongoing experience over the last 6 months in the debates in the House and the Senate and the press and the Supreme Court and the federal courts on where the emergency powers of the governor begin and end, and his ability to ignore the House and the Senate and the county commissioners and the mayors and the borough councils and the township supervisors because of this emergency. It suddenly becomes much less academic and very, very realistic. I don't want to even attempt to recall how many times I've been stopped on the streets of the district I represent in Schuylkill or Berks counties with people pointing their finger at me and saying, how can the governor do that? And as we have seen this week, different judges have ruled in different ways as to what is constitutional, what is not constitutional, and so it becomes a very, very realistic issue as to much more just everyday issues like how many people can sit in a restaurant? What do you mean I can't go to see my daughter at a volleyball game? And it's like, well, because the governor said this, and the House said this, and the Senate said this, and I guess we're all waiting to see if there's indeed going to be the promised veto or not on the fall sports legislation. We know one thing, that this governor has signed bills that he has pledged to veto. He has vetoed bills that he pledged to sign, and so we're all waiting to see what indeed will happen with that and the possibility of House and Senate override votes. But yes, it is academic in one way, and in another way, it affects whether or not I'm going to be able to go to a football game in Tamaqua tonight. So it's very, very real. And so again, Senator Phillips-Hill, thank you for bringing this subject forward. If there are no other comments, we stand adjourned.